commercial disputes of late, we can say a fad or otherwise, has been taking up everyone for the purposes of the legal perspective to the issue and what are the issues in this regard. And when I saw on the social media that Mr. Anirudh Krishnan, an advocate and an author, had penned down a book, Commercial Disputes Resolution, The State of Law in India, I thought this would actually help us to peep into the various spectrums in this regard. Before we request Anirudh to take over the session, I would just like to bring to the notice of all those viewers of the Beyond Law that Anirudh Krishnan is one of the first speakers when we started this legal journey of Beyond Law CLC during the COVID times. And thereafter, we have done 2 more sessions, one including with his father. And it has been a wonderful journey, and we have been following up each other on the social media. And we are thankful to him that he has accepted our invite. Before he starts the session, I will ask him to show the cover of the book and the publishers, and thereafter he will take us into this deeper dive of knowledge. Over to you, Anirudh.
Yeah, thank you very much, Vikas. I think it's wonderful reconnecting over a session after a while. It's wonderful to see that you've been continuing what started off as a very earnest journey during the COVID period. I think it's great that you've been able to keep it up. And as Vikas mentioned, we had initially penned down a book, my colleagues and I, on commercial dispute resolution. And then when Vikas read about it, he reached out and said, why don't you give a talk about it? So as Vikas mentioned, I will just show you the cover of the book. So the book is published by LexisNexis. And before I begin speaking about it, I think I must first point out this is not exclusively authored by me. I was the chief editor of the book, and a number of my colleagues, about 40, were involved with different colleagues of mine, both current and ex-colleagues, authoring different parts of the book. So it was a collaborative effort where we've gone into various aspects of commercial dispute resolution, which I will speak about during the talk today. I must also mention that we had a wonderful editing team, which was my extended circle here at AK Law Chambers. And therefore, it's a collaborative effort of everyone involved in this. So with that, let me and I must also thank Justice M.M. Sundaresh, Judge of the Honorable Supreme Court, and Mr. Gary Bourne, who were kind enough to write a wonderful foreword to the book. With this, let me go into some details of what the book deals with and other allied aspects. Now, the book is titled Commercial Dispute Resolution, State of the Law in India. Now, what we essentially look at is how commercial law has marched on in India post 2015. Why 2015? 2015 was a marquee year when it comes to commercial dispute resolution in India. Now, when you look at where we were in 2015, there was a lot left to be desired. In fact, I think when you look at our system, you can look at it from the point of view of the civil justice system, the ADR system, and the insolvency system. These are the 3 core facets of commercial dispute resolution in India. So when you look at what the position was in 2015, you had a situation where delays underlined the system when it came to all 3 facets. Let me start with the civil court system, where you had delays, you had adjournments, you have a civil suit that would go on. Well, if a civil suit was decided in 6 or 7 years, it was considered to be quick. You also had a culture where adjournments were the order of the day. You had by default parties seeking adjournments in matters which prolonged the litigation. As a result, how would you try and fast track commercial dispute resolution? You would try and identify what was the commercial weakness of the other side. You would try and see what kind of an interim order would bring the other side to the table to negotiate and close the matter. Therefore, Indian commercial dispute resolution was all about identifying that weak spot, going for the interim order, and it was a battle of interim orders. You would see interim orders being appealed, you would see interim orders traveling right to the Supreme Court, and ultimately, the outcome in the proceeding relating to interim order would determine the outcome of the civil suit. What was the problem? Why is it that interim orders became so crucial? That is because the final determination would take years. You had many clogs in the system, starting from the filing of written statements and the service of summons. So, in many cases, summons would take years to be served. Thereafter, the defendant would come on record. Defendant would take years to file a written statement. They would make use of judgments like the Salem Advocates Bar Association case to say that the time period stipulated in the CPC for filing of the written statement is directory, and you would have delays being condoned in filing of the written statement. There was also a lack of specificity in the system, which resulted in obfuscation of issues. So let me give you an example. Let's assume that there was a dispute in relation to, say, a trade secret and confidential violation, a confidential information being leaked by one party, confidential information and trade secret belonging to the other party. So the plaintiff sues for a suit on this account. For you to have a clarity, for the court to have a clarity on the matter, the first issue would be, is it an admitted fact that the information being described is in fact a trade secret? Is it an admitted fact that it is in fact confidential information? And then second is it being misused by the defendant? Now, very often on the first issue, there would actually be no dispute. But a defendant would simply say, I deny the statement and leave it at that. It is only if you force the defendant to provide a proper explanation will the truth emerge. A general denial would otherwise result in a long trial on issues that ought not to be adjudicated upon because, in fact, they are admitted issues. Now, the system as it prevailed provided for a situation where a defendant could come up with vague denials, could protract the entire proceeding. And vague denials, in fact, resulted in longer trials. It required every aspect to be proved. So traditionally, you will find that at the stage of evidence, the affidavits of evidence will often mirror the contents of the plaint because every aspect would have to be proved. Now, by providing for a system which requires specificity, it is possible to identify the real issues in dispute and focus on adjudicating those issues rather than going through the entire process. So the difficulty was that the lack of specificity in the system resulted in further delays. This is one amongst the many roadblocks in civil adjudication, which was a huge problem as of 2015. I'm not saying it's completely solved now, but things are much better and I will deal with those. Now, all of this resulted in a system that required parties to really push for an interim order to bring the other side to the negotiating table. This was the problem that we faced in 2015. So during in our book, we identify what the problems were in 2015. Then we deal with the legislation that came in that identified these problems, that dealt with these problems. Then we study these legislations and how they have worked, and whether in fact there are areas that these legislations can be improved. And then we suggest finally some potential aspects where the system can further be improved. That's in crux what we do in the book. So right now I have dealt with the issues that plague the civil justice system. I see a hand up. Is it somebody there have a question?
You will take the questions at the end, Anirudh, just like
right in the end. All right. Yeah. So then we come to the problem in the ADR regime. So when you look at arbitration, again you had the problem of delays. Well, it may not have taken 7-8 years, but you did have arbitrations easily run for 4 to 5 years, and then you had proceedings under Section 34 to challenge the award before court. Then you had one more appeal under Section 37, and then in some cases an SLP would be admitted. So while it was marginally faster than the civil justice system, the arbitration system was still very slow. Secondly, there was one major issue. Now, when you look at arbitration, you look at it as an outsourcing of the judicial system, where parties agree upon and appoint a neutral arbitrator. But when that neutrality is in question, then it goes to the root of the matter. You have a system which the sanctity of which is at stake when the very adjudicator is a biased adjudicator. In judgments such as Indian Oil versus Raja Transport, the Supreme Court prior to 2015 had taken the view that a public sector undertaking can appoint its own employee as an arbitrator, and such a system would not be a biased system. Now, if this is the standard that is to be followed, the sanctity of the entire process was in question. You had parties lacking trust in the system, which resulted in many challenges before courts, and courts could not adopt this hands-off approach because courts recognized that there was an inherent problem in the system. Now, therefore, in addition to delay, the issue of neutrality was a major issue that plagued the ADR and arbitration regime. A third major problem that plagued the ADR regime was the uncertainty in terms of time and cost. Now, there was no, one of the objectives of an ADR system is that since you have a private adjudicator, it is hoped that the private adjudicator can dedicate sufficient time and dispose of the matter quickly. But that was not happening. In addition, you had arbitrators usually charge fee per session. And when that was the case, there was a great incentive for arbitrators to have many more sessions. And they were quite happy to have matters linger on and on. So in a situation where the respondent was a financially powerful respondent, all they would want to do is delay the process, have more hearings, make it difficult for a claimant that was much smaller than the respondent to go through the process, and very often just wear the claimant out. So you had burgeoning costs, you had delays. All of these were beneficial to the adjudicators themselves, and hence as a system it was inherently flawed. All of these required urgent amendments, and that is where we were in 2015. The third regime that I'm referring to, as I refer to civil court regime, I refer to the ADR regime, and the third is the insolvency regime. Having a robust insolvency regime is very important. Why is it so important? a company that is under financial stress can take down many other good companies with it. A company that is in financial stress, that enters into multiple agreements with various other good companies, can result in dues accumulating to these good companies that may ultimately bring those good companies down. What you require is an effective insolvency regime where such a company is identified early, where dealings by such a company are stopped, and where steps are taken to revive such a company in an expeditious manner. This was not happening under the insolvency regime that we had in force prior to 2016. You had a system where you would approach the court for winding up under Section 434 of the Companies Act 1956. You will have that process linger on because ultimately it was discretionary. Even if there was a debt, there was no reason why courts would have to admit an insolvency petition. They could simply exercise their discretion of not entertaining the winding up petition on many counts. Further, you had a regime where you had the official liquidator take over the company once the winding up was admitted, and thereafter the official liquidator had a number of other companies to deal with. The official liquidator had a huge load with very little support, and at every juncture, for any major decision, the official liquidator had to approach court for permission. All of this resulted in a complete clogging up, and companies that could have been revived were never revived. Therefore, on all counts, when you look at it from a civil justice point of view, when you look at it from an ADR point of view, and when you look at it from the point of view of an insolvency regime, we were lacking on every count. In 2015, there were certain major changes, 15 and 16. First, you had the amendments to the Arbitration and Conciliation Act. Then you had the enactment of the Commercial Courts Act. And thirdly, in 2016, you had the enactment of the Insolvency and Bankruptcy Code. All of this drastically changed the commercial dispute resolution system in India. Let me briefly deal with each of these, and the book deals with these in the working of these statutes in great detail. First, with the Arbitration and Conciliation Act amendments. These amendments addressed a number of crucial issues that needed to be addressed. Firstly, a timeline was brought in. Originally 12 months. Thereafter, post another amendment, 6 months for completion of pleadings, and then 12 months thereafter for completion of the entire arbitration. So you had a process spanning 18 months, beyond which parties could agree for another 6 months by way of a joint memo, and thereafter parties would have to approach court if they required a further extension of time. Now, practically, this timeline has done wonders to the system. So even though the timeline that was contemplated is 18 months with a 6-month optional extension, inevitably parties end up going to court for a further extension. But what used to take 4 to 5 years now takes perhaps 2.5 years for completion. In matters that are simpler, I do see cases where the process is completed within 12 to 18 months. 12 to 18 months is an excellent timeline because even when you look at the mean for dispute for arbitration across the world, it is more than 18 months. So in that sense, there has been a timeline that is brought in that has worked wonders. Secondly, a regime has been brought in to ensure neutrality of the process. A short while ago, I spoke about how that was a very, very major problem in the system that was there. I refer to judgments such as Indian Oil versus Raja Transport. Indian Oil versus Raja Transport was legislatively overruled. The 2015 amendments brought in the 5th and 7th schedules to the Arbitration and Conciliation Act, which mirrored the International Bar Association guidelines on conflict of interest. Therefore, there were a set of relationships that were set out in the 5th schedule, which mirror the orange and red lists of the IBA guidelines. If any of these relationships exist, the arbitrator has to make a disclosure to both parties about the existence of such situations. And such situations shall give rise to a presumption of bias. So these would span from situations where the arbitrator had a direct financial interest in the dispute to situations where the law firm of one of the parties had been repeatedly appointing the same arbitrator, where they had appointed the same arbitrator in 2 or more disputes within the past 3 years. So various kinds of situations were set out, which brought in greater transparency in the process. You also had the 7th schedule, which related to the red list of the IBA guidelines, which set out even more drastic relationships, relationships where there was a direct financial interest, relationships where the arbitrator had advised one of the parties, relationships where the arbitrator had been or arbitrator's law firm had previously been involved in the dispute, etc. Now, if an arbitrator's relationship with the parties or the dispute fell within the 7th schedule, the arbitrator is automatically ineligible to act as an arbitrator. All of these drastically improved the system. Further, insofar as costs are concerned, there was an indicative fee schedule set out in the 4th schedule for arbitrators to follow. While many arbitrators still do not follow it, and it is not mandatory at the moment, things have greatly improved as a lot of arbitrators have chosen to go by the 4th schedule. This brings in greater certainty in terms of cost as well, but there are still areas to improve, and I'll come to that. So these are aspects where the Arbitration and Conciliation Act was amended, and that has worked well. In our book, we discuss in detail how these amendments have worked. We discuss also many problematic areas where the amendments have not worked. And in the last section of my lecture today, I will briefly deal with some of our suggestions. Now moving to the commercial courts regime. A short while ago, I mentioned the need for specificity. I mentioned the need for making the process faster. So the Commercial Courts Act has amended various parts of the CPC. And these amendments include making the timeline for filing of a written statement mandatory. So today, in a commercial dispute, the written statement has to be filed within 30 days of receipt of summons. For a period of 90 days beyond that, delay can be condoned. Beyond that, that is the end of it. Beyond 120 days, written statement cannot be filed in the matter. This has greatly speeded up the process. Secondly, there are many amendments that bring in greater specificity. Parties are required to file to specifically deny whatever statement that they are denying in their written statement. Further, parties are required to file a statement of admissions and denials, where they specifically admit or deny documents. This is again greatly useful, because if the content of a document alone is disputed and not the existence, then the plaintiff need not actually go ahead and prove the existence of the document. Therefore, the trial process can then be cut short to only proving disputed points and only proving disputed documents. Further, there is also a robust regime for discovery and interrogatories that is now in place. And all of these has helped improve the speed of the process. That said, I must say that there is a lot more potential for better usage of the Commercial Courts Act. And these are some aspects that we have dealt with in the book. There is a detailed chapter in the book that looks at the various aspects of the Commercial Courts Act and how, as a plaintiff, one can strategize and make use of the act to cut short a complex litigation. We look at how pleadings can be worded to ensure that it is split in such a manner that the defendant cannot get away with a general denial. So I would request all of you who get a chance to go through it and see whether it practically appeals to you, especially the chapter on the working of the Commercial Courts Act. The third aspect is Insolvency and Bankruptcy Code, which came in 2016. Now, what the IBC does is that it brings in a creditor in control regime. There is a time period of 14 days, though it is directory and usually takes maybe 3 to 4 months, for adjudication of a petition for insolvency. A petition for insolvency can be brought in either by a operational creditor or a financial creditor. A financial creditor is somebody who has loaned certain monies to a company. An operational creditor is somebody who has provided goods or services to a company and has not been repaid. Now, in the latter case, that is of an operational creditor, a demand notice has to be issued. There is a reply to the demand notice that has to be issued by the company within 10 days. And thereafter, a petition can be filed under the Insolvency and Bankruptcy Code. If there is a dispute, the petition will be dismissed. If there is no dispute, the petition will have to be admitted. In the case of a financial creditor, the only test is there a debt or not? If there is a debt that has not been repaid, then the petition has to be admitted. When you look at the statute, there is no question of there being any discretion, though I will come to the judgment in Vidarbha Industries, where the Supreme Court has read in discretion. That's one of the concerns that we have in the book and we have addressed. Now, once the petition is admitted, there is a fast-track process before the National Company Law Tribunal, where the creditors get control of the company. The financial creditors sit in what is called as a committee of creditors that oversees the process. There is a resolution professional who acts on behalf of the company, taking instructions from the committee of creditors and proceeds with various aspects of the process. The onus is on revival of the company, and many companies have turned around because of the efficiency of this process. However, there are still problems, and I will be dealing with some of those problems before I conclude today. The book deals with a number of these issues in great detail. But one area where I think the IBC has worked is that it has given a shock to the system. It has resulted in a system where a person running a company knows that in 3 months, he or she can completely lose control of the company. This has resulted in an increase in number of settlements, especially when there are operational creditors involved, because no promoter wants to lose control in that short a time frame. So even though the Insolvency Code is not a mechanism for recovery of money, it has effectively resulted in recoveries for operational creditors through settlements. So broadly speaking, these were the 3 major legislations in 2015-16 that kicked in, that drastically changed the commercial dispute resolution scenario in India. We have about 30 chapters of the book dedicated to discussing the working of these 3 legislation. Now, once we discuss these legislation, we also suggest areas where the working of this legislation can further improve. Now, I am not going to go into everything because for that you may have to go into details in the book. But let me set out a few highlights from each of these regimes where further fine-tuning would be welcome. Let me start with the commercial court regime. Now, when you look at the commercial court regime, there are 6 points I will try and highlight today. The first is a requirement for an increase in the threshold value. What is the threshold value? For a dispute to be categorized as a commercial dispute, it has to fall under certain categories. Dispute relating to a mercantile agreement or a shareholder agreement or a joint venture agreement. There are about 18 categories that are provided in the Act. In addition, the value has to be more than rupees 3 lakhs as of today. It started off as being 1 crore. Thereafter, it was amended to 3 lakhs. So today, there are a huge number of disputes that qualify as a commercial dispute, which results in the commercial courts getting clogged with a number of matters. Now, when you look at a lot of the mechanisms in the Commercial Courts Act, which provides for like a case management hearing, for specified timelines to be given by the courts to be implemented, these become difficult to implement when there is a very heavy docket. Then it just becomes old wine in a new bottle. What is required is a manageable docket for a commercial court or commercial division of a high court to effectively implement the provisions of the Act. Now, with this figure of 3 lakhs, which is an extremely low figure, you have various cases of small stakes also being termed as commercial cases, which results in the docket becoming large. In years to come, this docket itself will become unmanageable. So the only solution is to increase the threshold value, take it back to 1 crore or maybe even 2 crores. Second, you have one very well-intended provision, namely Section 12 capital A, which provides for mandatory pre-suit mediation. That is, when there is no urgency, parties must mandatorily be directed to mediation to try and resolve it before going in for an adjudicatory process. While it is very well intentioned, the Supreme Court in Patel Automation has taken the view that if a party does not go for mediation and directly files a suit, then the plaint can be rejected. This is a bit too drastic. In many cases, there will be genuine urgency where a party has to rush to court to seek interim relief. Now, if at the end of the day, well, while there is certainly a carve-out when there is urgency, if the court determines that, in fact, well, there was no urgency, then the effect is that the suit itself has to be thrown out. What happens to the court fee that is paid? A more effective mechanism would be to simply impose costs for violation of Section 12A and for thereafter referring parties to mediation. Further, the Act must also consider mediation at the post-trial stage. Very often, it is only after cross-examination do parties recognize the real strengths and weaknesses of their case. So, by providing for mediation at the post-trial stage, there will be many more settlements that will be possible, in my view. Hence, these are certain suggestions that we have made. I referred to 6 points. The first was on the increase in threshold value. The second is the amendment to Section 12A. The third is on service of summons. Now, in many cases, you will see that whether an interim application is filed, a party will participate through counsel. But officially, it will take a very long time for suit summons to be served. Sometimes it goes up to 1-2 years. So where a party files its wakalat through a counsel in relation to the interim applications, It must be suit summons must be deemed to have been filed. Such a provision is imperative. You have certain original side rules like the Madras High Court original side rules that provide for service of summons on the counsel entering appearance under Order 4, Rule 7 of the Madras High Court rules. A provision of that nature or something even more drastic, where if you file wakalat in the interim applications, suit summons is deemed to have been served. Because what is the purpose of summons? For parties to know that such a suit is going on. If they know and they have entered appearance in the interim applications, why have the procedural requirement of service of summons itself? Further, in relation to international proceedings, we have also dealt with the Hague Convention and provided for implementation of that. So the third aspect is service of summons. The fourth aspect is the effect of not filing admissions and denials. I referred to how admission and denials of documents is a welcome addition to the code and how today that increases the specificity in the adjudicatory process. Now, many defendants choose not to file it. Now, what is the consequence? That's not provided. So perhaps including a provision wherein not filing of an admission and denial would mean deemed admission of all the documents will help improve the efficiency of the process. That will force defendants who want to obfuscate the issues to, in fact, be specific, and it will prevent them from abusing the process. The fifth, and this is extremely crucial, the Commercial Courts Act provides for case management hearings, where courts set out a schedule for trial, dates on which affidavits have to be filed, dates on which cross-examination will take place. Now, in an overclocked system, these dates become very difficult to meet because there are 7-8 matters scheduled for trial on a particular day. Cross-examination in 2 matters may take the full day. So what happens to the remaining? You go back to court and get an extension. Now, 2 ways in which this can be overcome is first by providing for commissioners recording evidence. The provision for this is already there. It is used in places like Delhi, it is used very often, but other places like Madras, Bangalore, etc., it's not as common. So perhaps a method of making this more common would help meet the timelines under the Commercial Courts Act. Further, it would also be helpful to embrace technology. You have today instant transcription technologies that are available at reasonable cost in the market, where instead of following the traditional method of dictating questions and then the witness dictating the answers and the steno typing this out at a very slow pace, you have softwares that instantly transcribe, where it is a lifetime conversation between the cross-examining counsel and the witness, and that is automatically recorded. Well, of course, you don't have the problem. You will have certain teething troubles, like you will not have the judge or the master, as the case may be, modifying the language, etc. But ultimately, when you have a recording, the truth comes out. This not only speeds up the process, but it also creates a scenario where the witness does not then think about, oh, where is this lawyer going with this line of questioning? It is lifetime and the truth comes out. This is the method used in every international arbitration. It is starting to be used more in domestic arbitrations, but I think using this in our commercial courts will greatly help fasten the pace of commercial dispute resolution. The last point I would like to mention when it comes to the commercial court regime is including a realistic cost regime. The provisions are now there. Both the Commercial Courts Act and the Arbitration Act provide for a regime for costs based on the UK system, whereby costs follow the event. So the losing party has to bear the entire costs. but I rarely see courts actually implement this. Now, this is very crucial because if a party files a frivolous case and has to spend an enormous amount, the entire court fee plus the lawyer's cost of the defendant if that is passed on to the plaintiff who files a frivolous case, then over a period, frivolous cases will stop being filed. So implementing this regime for costs is crucial. The amendment is already there, but courts will need to implement these, will have to implement the letter of the law in relation to costs. These are only 6 points. There are many other points that are discussed in the book, but I'm only providing you a broad overview of some of the issues that we have examined. I have given you the conclusions here. We have examined each of these issues in greater detail, plus other issues. We have set out in relation to the Commercial Courts Act a detailed study of the provisions in relation to discovery. We have gone into the aspects of appellability under Section 13. There are various other topics as well. I'm only giving you a broad overview. Then coming to the ADR regime, let me set out 6 points here as well. First, even though the regime has improved in relation to neutrality, you still have some problems arising out of panel appointments. So the Supreme Court has held that unilateral appointment of arbitrators by one party is bad in law, but has held that a party can give a panel of 4 or 5 to the other party, and the other party is forced to choose from that panel of 4 or 5, and that such an appointment system is valid. This judgment in Central Organization for Rural Electrification by a 3-judge bench, with great respect, is incorrect. It is currently being, in fact, it's before a larger bench. I also appeared in that matter. It's now reserved for orders. Hopefully, we will have core overturned shortly. That's one of the points that we mentioned in the book. The second is the evergreen issue in relation to what is the seat of arbitration, what is the venue of arbitration. Now, with respect, the judgment of the Honorable Supreme Court in BGS versus Soma rewrites the provision of Section 2(1)(e) of the Arbitration and Conciliation Act by saying that only courts at the seat will have jurisdiction. Now, in the context of international arbitration, it is well settled that courts at the seat will have, only the courts at the seat will have jurisdiction. And that is because there are a lot of things that attaches to the court at the seat. Namely, it is only the courts at the seat where you can actually challenge an international arbitration award. But this was not meant to be something that was supposed to be incorporated within India for a domestic arbitration. For a purely domestic arbitration, you had Section 2(1)(e), which basically provided that you will go to the court which you would have gone to had it been a civil suit. That was the mandate of the law. But in BGS versus Soma, the Supreme Court has imported what applies to an international arbitration into a purely domestic scenario and virtually rewritten Section 2(1)(e). There are 2 chapters where we discuss the concept of seat, the concept of venue, and we have discussed how the judgment in BGS versus Soma is contrary to Section 2(1)(e) and contrary to the judgment of the Supreme Court in Balco, which is a larger bench. A third aspect that we deal with is in the context of fees of the arbitrator. There is a detailed judgment of the Supreme Court in Afcon's case, where issues relating to arbitrators' fees has been discussed. And we have also gone into that. We have also, in fact, advocated that maybe the 4th schedule should be made mandatory, subject to the parties being given an option to opt out of it. Now, I'm going to run through this because I'm a little short of time. We've also gone into the aspect of modification and severability of arbitration awards. Now, this matter is pending before a larger bench. Now, we have set out the difference between severability. So, for instance, if there are 5 claims and the Section 34 court holds that 3 out of the 5 are bad in law, the findings are bad, then it can sever it and say, we are upholding the award in relation to the other 2. In relation to these 3, we are severing it. Severability is different from modification, where modification is where within a claim, say a claim of 1 crore is granted, the court under Section 34 goes ahead and says instead of 1 crore, we'll uphold up to 75 lakhs. This amounts to modification, which according to many judgments of the Supreme Court, like McDermott and Hakim, are not permissible. But this has now been referred to a larger bench and is pending before the Supreme Court. We have dealt with this aspect in great detail, and we have advocated in the book that a legislative amendment has to be brought in to permit a limited form of modification. Because now what happens? The court says, all right, the finding of 1 crore is not justified, should be a lower figure. But the court cannot specify the lower figure. Therefore, it has to set aside the award, which means you go back and re-arbitrate. So it's almost like an endless loop, and it further defeats the purpose of the act if a party is pushed into re-arbitration. So we have suggested a mechanism where the court under 34 and 37 should be given a power to appoint an arbitrator for determining this limited issue, given the specific needs in India. Though what we have suggested is something that is not there in the laws of any other country, we feel that this will greatly help, given the sui generis scenario in India regarding arbitrations. Then let me very, very briefly touch upon 2 other issues and then leave it open for questions. On the issue of limitation, and there is a controversy arising out of the judgment of the Supreme Court in Geo Miller. We have discussed that, where there are negotiations between parties, there's a mediation, then does it have an impact on limitation or not? When you look at the act, it should not. But practically, in many cases, mediation is provided as a precursor to arbitration. So if you spend 4 years mediating genuinely, do you lose limitation? The Supreme Court in Geo Miller says you can exclude that period in which parties were genuinely negotiating or mediating. You must identify the start, you must identify the breaking point and exclude that period. While we agree with the practical aspect of Geo Miller, we have advocated for a legislative amendment to incorporate this, since today there is no legislative basis for it. We've also briefly criticized the ministry notification which says that by default, a dispute of more than 10 crores should not be referred to arbitration. Now, before I wrap up and open the floor for questions, I'll deal with the insolvency regime. Now, I mentioned that under the insolvency regime, the level of discretion has been brought down. That so long as there is a debt, the NCLT has to admit a petition for insolvency, so long as there is a debt which has not been repaid. Now, this was the position for many years based on the judgment of the Supreme Court in Innovative. But a recent judgment of the Supreme Court in Vidarbha Industries takes a contrary view. Now, that brings in discretion, and that is quite dangerous for the system. With respect, I think Vidarbha is contrary to the judgment in Innovative and would have to be read as being per incurium to it. There are some legislative amendments that have been proposed to overrule Vidarbha. The second is an aspect called project-wise corporate insolvency, where you look at the insolvency of a real estate company or a construction company. There are many projects that are individually the company is working on. Now, to club everything results in a very messy insolvency. But today, each of these projects cannot be segregated in law, because today all of them are being operated by one company. But practically, the NCLT has gone in for project-wise CIRP in some cases, which is a very good practical solution, but unfortunately lacks legal basis today. Therefore, what we require is a strong legislative regime that brings in a scheme for project-wise CIRP, and this is one aspect that we have discussed in great detail. We have also gone into the aspect of group insolvency. So let's assume that there are 3 different group companies that are in insolvency. Can it all be clubbed into one and dealt with by one single resolution professional as one single process? Doing so destroys the independent corporate identity theory, the age-old Solomon versus Solomon principle. But again, this is a practical need, and there are various judgments of the National Company Law Appellate Tribunal that discuss it. We propose for a regime to actually recognize this and statutorily provide an exception to Solomon versus Solomon in this regard. Briefly, before I conclude, we also discuss contingent claims. Today, contingent claims which are pending adjudication during CIRP are often given a notional value of 0, which is completely unfair. So we've provided for mechanisms where we look at mechanisms abroad, we look at expert determination, and look at other practical measures that can be brought in statutorily to help resolve this situation. We also deal with situations like the modification and withdrawal of resolution plans, because in EBICS, the Supreme Court says that once a resolution plan is submitted, you cannot modify it in any manner. But what about a situation where, for no fault of the resolution applicant, he makes that initial payment, and for the next 2 years, the matter is stuck before the NCLT? Should the resolution applicant suffer? The decision in EBICS does not take this into consideration and requires urgent reconsideration. Lastly, we also deal with the scheme for cross-border insolvency, but that's a topic by itself. I'm not going to go into details right now. But these are all topics that we have gone into in great detail in our book. In addition, we have identified various commercial issues that arise, some that are live issues today, like construction of enforcement of exclusion clause that says that even if in a contract between A and B, if B breaches, B is not liable to pay damages. Is such a clause valid? We have dealt with the various conflicting Supreme Court judgments on this point. We have looked at aspects such as protection of trade secrets, protection of confidential information, creation of confidentiality clubs. We have also attempted to analyze a few futuristic issues such as cryptocurrency. We have also analyzed disputes that we see arising out of the COVID pandemic and how that has impacted commerce and how they should be looked at by courts because a lot of these are currently being adjudicated. They are raised in arbitrations, but there isn't much precedent on them. So a lot of these are there. I would invite all of you, if you get the opportunity, to go through it. And we'll be very, very happy to receive any critical comments from you, because at the end of the day, when there is any academic work, the idea is to put the thoughts out there. There is often a difference in view on what the position should be. There might be flaws for which I take entire responsibility, but anything that any of you would like to point out to me, we'll be happy to incorporate. And hopefully this is work in progress, and there'll be a second edition in a few years' time. Thank you very much. Now, any questions, I'll be happy to take.
Yeah, Anirudh, first question is whether a commercial suit is maintainable against an agricultural loan.
Relation to a?
Commercial agricultural loan. Like in SARFAESI, we have seen that they've carved out an exception.
Yeah, there is no exception under the Commercial Courts Act. So today, so long as it's a loan, there is no a finance agreement is something that is covered by Section 2C of the Act, and therefore a commercial suit would lie.
This is by Panchkasa Sundaram. Whether unilateral appointed arbitrator award can be challenged under Article 227, whether Section 47 CPC is barred questioning the arbitration award.
Sorry, let me deal with unilateral appointment first. Now, unilateral appointment, you will not go under 227. If there's a unilateral appointment of an arbitrator, you can go under Section 14 of the Arbitration and Conciliation Act to say that unilateral appointment is contrary to the 7th schedule as laid down by the Supreme Court in Perkins and Bharat Broadband, and therefore directly you can go under Section 14 of the Arbitration and Conciliation Act and challenge the appointment before the court. You will not go under Article 227 because 227, the court will say that you have another remedy under the Act itself.
Next question
And sorry, court has also gone as far as to say that you can, even after participation, challenge it under Section 34, so long as there is no express waiver in writing after the disputes have arisen. There is a judgment of the Madras High Court in Chennai Silks to this effect.
Whether an arbitrator can attach immovable property by directly communicating with the sub-registrar without the intervention of the court.
An arbitrator can pass an order under Section 17 for attachment before judgment. That power is there. And today an order passed under Section 17 is equivalent to an order passed by a court. That is a specific for 17.5, I think, which provides for that. Therefore, that power is there.
So these were the only 3 questions, and we are happy that you have shared your knowledge. Thank you, everyone. Stay safe, stay blessed. Namaskar.
Thank you, everybody, for joining. It's been a pleasure addressing all of you. Thank you very much.